This presentation is called Don't Sign That Division Order. This is related to division orders related to Oklahoma wells. When I say Oklahoma wells, I mean oil and gas that is produced within the state of Oklahoma, even if the company sending the division order is from another state. Laws of other states are different, so this presentation only applies to division orders related to oil and gas wells within the state of Oklahoma. My name is Richard Wimblad. I'm an attorney licensed in Oklahoma. I've been practicing in Oklahoma since 1992. This information and the comments herein are not legal advice. They do not create an attorney-client relationship, nor is this a substitution for obtaining legal advice from a licensed attorney. This presentation only discusses division orders related to oil and gas and other minerals produced from Oklahoma wells. If the well is not from Oklahoma, much of these materials will not be applicable. Although not required, refusal to return a division order may result in delay in royalty payments. So what exactly is a division order? A division order is a document or a form sent from a company that collects information about the royalty owner or the person who's due to be paid. The receipt of a division order is an exciting event because it means that there are minerals being produced and the company is about to start paying. The division order request will ask for some pretty simple information such as the owner's name and address, phone number, social security number. Often it will ask the owner to confirm its fractional interest, to warrant title to the property, and impose conditions and obligations beyond what is required by law from an owner. When do companies send out division orders? Division orders are typically sent once there are sales from production of oil and gas from a well. Often these are sent within 6 months after production begins. There are several dirty little tricks that are hidden within the division orders. First of all, they ask an owner to certify the decimal interest in a well that is being produced. The division order may have indemnity or other obligations that the owner is not required to agree to as a matter of law. The letter accompanying the division order may suggest or state that returning the division order is required before you begin receiving payment. It may also ask you to warrant the title of your property. There may be a threat of withholding or delaying payment unless the division order is returned. Well, that's what the company tells you, but what does Oklahoma law say? Well, Oklahoma statutes and the Supreme Court are on the side of the mineral owner on the issue of division orders. In fact, there's an Oklahoma Supreme Court case called Hull versus Sun Refining. The company was not paying a mineral owner its royalties, and the reason for it is they said the owner did not return a division order. The Supreme Court considered that, reviewed the law, and came to the conclusion that requiring owners to sign division orders before receiving payments is violative of public policy, and they ruled for the mineral interest owner. Here's my favorite part. The company withholding payments was required to pay the owner's attorney fees and costs. You heard right. In Oklahoma, division orders are not required. There's a lot of talk about the National Association of Division Order Analysts model form. Is that form okay? The short answer is no. While the form looks pretty innocent, there are some hidden traps inside of that number one, aren't required by Oklahoma law, and number two, you don't want to sign. Although the model form eliminates many of the abusive clauses that some companies attempt to add to division orders, there are still reasons why you would not want to sign the model division order. A division order will give you what's called a owner's decimal interest number and then asks you to confirm it. The model form asks you to agree as follows. The undersigned certifies the ownership of the decimal in production or proceeds as described above payable by the company. So what is a decimal interest number or owner's interest number? That is typically a percentage that shows up something like this. To determine the percentage number, it's a complicated calculation and you'll need the following things: the number of net mineral acres you own, the amount of royalty to which you're entitled, the number of acres in a spacing unit, and if it's a horizontal well, the number of perforations related to your interest or in that section. So why shouldn't you certify the decimal interest? Well, determining the number of net mineral interests is difficult. Most owners do not have an independent oil and gas title opinion which outlines their net mineral acreage. One cannot rely on a deed or a probate order. Instead, examination or abstract must be conducted to get to this number. Oil and gas companies employ division order analysts to examine title and determine the interest. These are highly trained individuals who receive a lot of training on how to do this. However, they do make mistakes sometimes. You will also need a copy of the lease or pooling order, the size of the spacing unit, and if it's a horizontal well, the percentage of perforations within your section from the survey. And finally, it's their job to determine that. There's nothing in the law that says you have to certify that they did their job right. The number 2 reason you should not use the model form. Number 2 reason is, should you pay for their mistakes? The model form says the undersigned agrees to indemnify and reimburse payer for any amount attributable to an interest to which the undersigned is not entitled. In other words, if they make a mistake and they overpay you, then you have to indemnify them and pay back the payer. If you are overpaid, the company may have some remedies, but there's no reason to give them extra remedies to which they're not entitled. The third reason is there's no reason to alter the minimum pay. What Oklahoma law says that if the proceeds are under $100 but more than $25, the owner can request payments monthly. And if proceeds are less than $10 monthly, the owner may request that they be paid annually. So there's no reason to say that you will only be paid once the proceeds reach $100 or more, because that can delay payments you're entitled to receive on a more timely basis. If your lease has a no deduction clause, this should be highlighted in the information provided to the company. So to recap, the NADAO Model Division Order is not okay in Oklahoma. Number 1, division orders are not required whatsoever in Oklahoma. Number 2, they ask you to certify a decimal interest that you don't have the information or training to do so. Number 3, they impose liabilities on the owner that are not required for law. Number 4, they do not provide the best payout rules under the law. And number 5, they don't provide a way for an owner to communicate about no deduction clauses. Okay, we've talked about a lot of things why we should not use the division orders or even the model division order form. Instead, what should you send? Number one, send your IRS form W-9. Otherwise, the company will withhold the maximum amount as required by the tax code. Number 2, send a letter explaining that you will not sign the division order with reference to the statute and the Supreme Court decision. Number 3 is provide them with a form that provides them the relevant information, the minimal information, in order for them to begin making payments. And finally, provide a statement about interest due for non-payment. What if a company doesn't pay? If you have title to the property, the company cannot refuse to pay under law for refusing to return a division order. In fact, under Oklahoma law, when payments are not made timely, they are subject to a 12% interest that is compounded annually.